let's raise the questions. End of the road, therefore, for sedition law or not? Will the government now act on its promise it has made to re-examine this law? Has the Supreme Court done what the executive failed to do? Big step forward for the country in the battle for free speech? Yes or no? Joining me now is Mahua Moitra. She's there as a Trinamool Congress MP, but importantly today as also one of the petitioners in this case. And Aryama Sundaram, senior lawyer, Supreme Court. Appreciate the two of you joining us. Mahua Moitra, do you see this as a victory today for free speech? Or do you believe it's only a temporary respite, given the fact the government has said it's re-examining the law? The law is still there, or is going to be there in the future if the government so chooses. How do you see today's order?
Look, Rajdeep, it's definitely a step in the right direction. And I would say it is a historic day because look what happened. 1962 was the last time that the Supreme Court examined this. The government says that this law is necessary and with reasonable restrictions. But in 1962, a 5-judge bench of the Supreme Court already laid down what it said were reasonable restrictions to the misuse of this law and said that imminent lawless action, incitement to violence for subverting government were the only times this law could be used. So mere criticism of the government and mere using constitutional means to protest or to dissent could not be termed as sedition. But we've seen in the last 5 to 7 years that obviously the 1962 judgment has been thrown out the window, and governments all over India, state and central governments, have used this law as a tool. In fact, the British used it to throttle Indian voices, and the Indian government, an elected Indian government, has done exactly the same thing. So it is important today that
may I add, Mahua, Moitra? No, ma'am, including state governments, because when it comes to free speech, you've seen even the Trinamool government has clamped down on those who have been critical of you.
Rajdeep, let me finish. Why are you getting so excited? Let me finish. Yes. Obviously, police is on list 2 in the constitution. Obviously, it's a state subject, so obviously state governments will do it more. That's pretty obvious. That's not the point. The point is because the law existed, there was room for people to misuse it. This law should not exist. And the most important thing here is that the government has come in and said, first the SG and the AG were on different platforms. The Attorney General was ready to argue. The Solicitor General says, please leave this. The court has no business looking into it. The government then comes in after 8 years of being in office and says, we will reconsider it. Please note, they use the word reconsider, not revoke. What is to stop this government, and we have seen this in the past, from their brute majority, from bringing in a revised version of this with amendments rather than revoking it, and amendments like silly ones like the one they put up in court, which is to say an officer of the rank of an SP or above can look into it on a case-by-case basis. That's just carte blanche to misuse it again. What the court has done, Gopal Shankar Narayanan, who was appearing for me in the case, put in a 1-page submission in which he said, let the central government go in and reconsider it. Beware, they have not even put in a timeline. So it might take months or years or whatever, and the government cannot place on affidavit what Parliament is going to do. The government cannot do that. So Parliament alone can legislate. Given that we do not know what timeline we are looking at, the Supreme Court has said that no new FIRs can be filed on sedition, and people who are in jail for sedition, people who have been arrested, have the right to recourse. In immediate recourse as in bail, and all chief secretaries, all senior police officers have been informed that this is the situation. So I think this is definitely a victory. Of course, this is, historic.
You know, it is historic, but I will just press you one more time before I turn to Aryama Sundaram, just to say this. Do you therefore concede at one level that the state governments, it is not just the Modi government's problem, it's also state governments across the country who have misused it? No, 1 minute. We've seen Uddhav Thackeray, government in Maharashtra used it against Navneet Rana, a political rival, for reciting Hanuman Chalisa. We saw last year how the Delhi police was used to arrest Disha Ravi, an environmental activist. We've seen in the context of free speech, misuse of other provisions by your government to arrest a cartoonist who was critical of Mamata Banerjee. My point is, if the attitude, the mindset of the state does not change, the police will be used as an instrument.
No, that's exactly why we need this law to go. And let me place on record, the cartoonist was arrested under 66A, which has now become infructuous, not under sedition. And West Bengal, since 2014, since our government came to power, has only 10 cases of sedition filed, which again, had this law not existed, should not have been filed. So there's no question that the state governments are using it, because obviously this is police is on list 2. So obviously state governments will use it. That's number one. It's not a question of, which pot is blacker than the other, or sort of, who's more to blame. The question is, when you have a law that has no place in a modern constitutional democracy like ours, the law needs to go. If the law exists, everyone is under temptation to use it. So the law is bad, and we need this law to go, which is exactly what the first step the Supreme Court has taken.
Aryama Sundaram,
the central government
just a minute, ma'am, now.
Accepted it. The central government should not have tried its best to stall it, and the intentions of the central government are clearly not above board. Even now, they're doing their best to come up with all these red herrings. They should just
Aryama
say,
Sundaram,
what?
is it bad in law? Do you believe that effectively what the court has said today, they spoke about the social milieu. They believe that this law in the present social milieu is a law that should not exist on this. Just a minute, ma'am.
Yeah.
Let Aryama Sundaram.
Rajdeep,
is it prima facie, according to you, the court's message to the government now that this is unconstitutional, or is the court waiting to see what the government does? They've said we hope and expect that the government will act on it.
Look, Rajdeep, I'll tell you, there's a very simple issue here. You have a section 124A which deals with sedition. Now, one can understand sedition as being something which is necessary to see that nobody attacks the sovereignty, integrity, security of the country. Not a political party in power, not the government of a day, not criticizing policies of government, etc. That is not sedition. What sedition ought to be is really something more akin to threatening the security, integrity, the sovereignty of the country itself. Unfortunately, Section 124A, because it was drafted in the colonial years where it had to protect king and country, and therefore they had to keep the colonial rule going, has been so widely defined that it is today absolutely untenable in our present day constitution. The point is, sedition can stay, but in the context in which it should be understood, which I've already said, sovereignty, integrity, security of the country. But
no, so are you saying it should stay? No, 1 minute. Aryama Sundaram, are you saying it should stay on the statute books? Are you saying it should stay on the statute books? Because as I said, once it stays on the statute books, given the fact that police powers can be misused, it will be misused again. So when the government says it's going to review and re-examine it, what does it mean?
124A as it stands has to go completely. And if you want something which is akin to a punishment for treason, then enact a totally different section for that. Now, so far as misuse of a provision is concerned, I'm afraid every statute you find misuse. You find income tax officers misusing that provision. You find ED officers misusing their powers there. Now, misuse happens. That doesn't mean the law is bad. It means the exercise is bad, and the courts are there for that purpose, and that will always happen. My point is that the section as it stands today is something which is so capable of interpretation, misuse in every way because of the way it's been drafted so loosely, and this section has to go.
So what can the center do? No, Aryama Sundaram, when the center goes, just a minute, sir. When the center goes to the court and says we are reviewing and reconsidering it, 48 hours after first saying it's necessary. Remember, this is the same central government which on Saturday said it's necessary. On Monday files an affidavit saying we are ready to review and reconsider it. Why should I trust the central government that they will review and re-examine it in a manner that will ensure that it is not misused?
Well, what my answer to that will be, it has been very clear that the Prime Minister then took a decision that it was something which needed to be relooked at in view of the views expressed by the court, in view of the general sentiment about it, in view of the fact that it was today, in today's context, something to be relooked at. And the government has made a statement to the court. It is always expected that when the government makes a statement to the court, it says so with all honesty and all bona fides, and I do not see any reason right now to disbelieve it, nor do I think will the court take this lightly. The court will also see it as the government says they're going to look into it. We take the government, and that's the Lakshman Rekha, which the court has respected, and says, look, you the government say you're going to look at it, we trust you, but in the meantime, do not utilize the section as it stands, since you yourself say the section has to be revised. You yourself as a government say the section has to be changed.
Sir, just a minute. The next hearing is in July. the Chief Justice retires on August 26th. What stops the government from pushing it well beyond August 26th and allowing it to die down? Once all this brouhaha around it dies down, this will be consigned to some legal cupboard. What stops the government from doing that? Why are you so sure that the government is serious about re-examining sedition suddenly?
Well, possibly, Rajdeep, I have far greater confidence in the Supreme Court of India than what you are afraid of. The Supreme Court of India is not a court which is going to take such a representation of the government lightly. The Supreme Court of India has posted the case to the third week of July. I think you should wait till the third week of July and see what the government comes back with and see how the court deals with it. But the fact of the matter is this: the court has prima facie expressed a clear view that this is something has to be relooked at completely. The government has been responsive enough, at least in the recent past, to say, yes, we also agree. The natural corollary of that was the court said, very well, you also agree it has to be relooked at. We will give you that chance to relook at it, but meantime, we are staying the provision. So as on today, it is as though that provision is a dead letter from the practical point of view. It cannot, proceedings cannot be continued, the section cannot be used, people who have been booked under it can get their bail, and we'll have to wait till July. And I am not inclined to say that the government has said something so lightly and so flippantly that they are going to go back on it. We will wait till the third week of July, see what is said, and I have enough confidence in both the court as well as in the government's words to believe that the government will come up with something, and the court is definitely not going to put this in a back burner. The court has made it very clear that they're going to consider
Mr. Sundaram, as a journalist, the reason I have skepticism is twofold. Number one, a number of people who've been charged with sedition also have serious UAPA charges, anti-terror law charges against them, and criminal conspiracy. So while they may be let off on sedition, there will be other charges. Number two, this is the same government which over the last 1 year, since this matter was moved first 10 months ago, didn't do anything about it. Suddenly, Mahua, Moitra, they wake up. Which is why, are you as sanguine as Mr. Sundaram believes that by July, the government will come up with an answer? There's a parliament session in July. Do you expect sedition law to be re-examined and we'll have a new law by July? Do you really expect that?
I agree with Aryama completely on one point, that we have faith in the Supreme Court of India, and that the Supreme Court, the fact that they've posted it for July means that they've definitely put some kind of timeline on it, though the government itself did not commit to any timeline. And like I said, the government cannot commit to a timeline on behalf of Parliament. That doesn't work like that. A. B, the thing is, if it came into Parliament, if it does come into Parliament, I'm sitting in the opposition, I'm in the Lok Sabha. We have seen this over and over again. The government has said nowhere that they will revoke the law. The word they have used is review and reconsider. They could very well bring in an amendment to this, in which they say that in each case you will have the SP of a district look into it on a case-by-case basis. And they had the brute majority in the Lok Sabha to pass it. They now even have majority in the Rajya Sabha to pass it. So we will again be faced with a situation where on the books this law is there, it's an amended law, and we've got to go in and again, and they've kept their word and said they've reviewed it and reconsidered it. But by the way, the law for all practical purposes would remain as it were. So in that case, I think the Supreme Court, and by going to the Supreme Court, we've done the right thing. The Supreme Court, by putting the law in abeyance while the government takes its own sweet time to do whatever it has to do, and giving them the benefit of every doubt, the Supreme Court has laid down all of the sort of protections that citizens require today.
Let me leave it there. Clearly, one step forward.
Sure,
I'm
sure that both you and Mahua will agree that a mere cosmetic change is not going to fool the Supreme Court of India.
I hope so.
That the Supreme Court of India is not going to view a cosmetic change as a real change. And I don't think the government also, when they're saying this, intend a cosmetic change. I'd like to believe that both the government is sincere in what it's saying, and I see no reason to think otherwise. And I have enough faith in our courts that the courts will see to it that this cannot be a misuse provision in future.
That's the difference between a senior lawyer of the Supreme Court and a not so senior journalist who perhaps has been trained to be very skeptical of what the political executive does. Mahua, Moitra and Aryama Sundaram, appreciate you joining us.